Hello friends, we will take 10 more questions from our series to learn a little more polity. Do focus on the additional parallel learning through the images on the screen and also the end lesson on political spectrum after the last question. So let's take the first question. It says, according to the Constitution of India, where a dispute arises as to the age of a judge, two options are given. In case of a judge of a high court, the question is decided by the governor of the state. Now, this is where comes Article 217, Clause 3, which says that it is to be decided by the president in consultation with the Chief Justice of India. So, first statement is actually wrong. Then, in case of the judge of Supreme Court, it is determined by the Chief Justice of India. Now, this is discussed under Article 124, Clause 2A. And it says that in such a case of Judge of Supreme Court, it has to be determined by such authority as the Parliament may by law decide. Parliament has not made any such law so far. This provision was just added but never implemented, and never such issues have arisen. So we don't know actually what is the authority. But yes, it is not the Chief Justice of India. It is Parliament by law who will decide. So both are actually the wrong answers. Then in the next question, it says which of the following statements is correct with respect to the judges of Supreme Court of India. Now, first state there is no tenure for the judges. That's absolutely correct. There is no tenure. Only thing stated in the Constitution is up to the age of 65 years. Similarly, there is no minimum age for the appointment of judges. This is also correct. No age related qualification is there in Article 124, or similarly, even for the High Court judges also. So, both of these are correct statements. Then, in the next question, how many of the following bills can be introduced by a private member of the Legislative House? Some options are given: money bill, financial bill, constitutional amendment bill, bill to provide permanent bench, a bill to include a new language. I just wrote as many things, just to create more and more options. The point is there is no prohibition whatsoever either in the Constitution or in the rules of procedure of the Houses of Parliament. Any bill can be introduced by any member. So remember this principle: any bill can be introduced by any member, whether they are a minister or they are a private member, it doesn't matter. There is a lot of misinformation in this regard in some of the renowned books too, and of course also in the online world where it is anyway difficult to figure out the authenticity of the information. And mostly it is in regards to the money bill, because money bills require recommendation of the president. So yes, it is presumably going to be difficult for private members to get that recommendation, right? Private members may find it difficult because the council may not recommend to the president, considering it is not their bill. And without council's recommendation, president would not recommend the bill. So yes, it may be difficult, but is that a prohibition? Not at all. In fact, there are examples, very rare, of private members' money bill passed as well. I have discussed that in another question in the first season. If you have difficulty handling these or similar conflicting points of information around you, do not accept anybody's writing or speech, like mine here included. Do your own research to be convinced. One, by using principles and inherent logical reasoning, and second, by finding evidence. If you are seriously interested, then go to Lok Sabha website and check the section of bills and choose the filters to get private members' money bill. And here is what I found a few days ago. You can pause and see it at ease. These are money bills introduced by private members in the Lok Sabha. You can check yourself as well. So anyway, all five, basically any bill can be introduced by private members also. Then next question says, justice should not only be done, but should manifestly and undoubtedly be seen to be done, is the most direct corollary of which of the following? First says rule of law. Now, its core idea is a rule of law, not a rule of men. Correct? That is to say, it promotes non-arbitrariness. And hence, transparency is essential in decision making. Right? So yes, indirectly in some way, rule of law is also promoting that justice should be visible. But that's a lot of correlation to be done here. It's not a direct corollary. So we should see other options also. Second says principles of natural justice. Now, there are three principles we know: to give a hearing, fair trial, speaking order, not deciding one's own case, and acting in good faith without bias. And why to do all of that? For justice to be also seen as justice. And I hope you know that this is the first value in the restatement of values of judicial life of 1997, adopted by the full court. Here it is. See, read. Justice must not merely be done, but it must also be seen to be done. The behavior and conduct of members of the higher judiciary must reaffirm the people's faith in the impartiality of the judiciary. Accordingly, any act of a judge of the Supreme Court or High Court, whether in official or personal capacity, which erodes the credibility of this perception, has to be avoided. So, in an ethics paper, also this can be used. Nevertheless, third option says doctrine of pith and substance. Pith and substance, this is mainly for examining legislative competence. And so is the next one, doctrine of colorable legislation. In pith and substance, the court shall examine the real purpose and intention of the law, which, if is within the competence of the legislature, then the court shall uphold the law, even if it trespasses into another legislature's competence area. Because the main intention is that. Now, in colorable legislation, which is counterpart of pith and substance doctrine only, if the court finds the intent of the law is to actually legislate on a subject that is not in their competence and it is making to look as if it is within their scope, such a law will be declared invalid. What cannot be done directly can also not be done indirectly. Let's move on to the next question. It says which are correct under the 10th schedule of the Constitution. First statement: a member who is disqualified under the provisions is also disqualified to be appointed as a minister. This is absolutely correct. In fact, it is a provision under Article 75 of the Constitution, which was added by the 91st Amendment of the Constitution 2003. This amendment had also removed the protection for splits, where not less than one third of the legislature party members could form a new party. Not now. So it has been amended. So not allowing disqualified members to be appointed as a minister was also done, even for the 6-month period, right? Otherwise, normally we think ministers can be appointed, but if they're disqualified, they cannot be appointed as a minister even for that 6-month period, because that is how it used to be misused earlier. Second statement says if a question has arisen as to whether the speaker has become subject of disqualification, questions shall be decided by deputy speaker. Now this is wrong. Normally you would think like this, but under para 6 of the 10th schedule, it states that for the speaker or even the chairman, wherever applicable, the question of their disqualification shall be decided by any such member as the House may elect. So the House will choose one of the members to be deciding those cases of the presiding officers. Third statement says if a member is expelled by their political party, they are not subject to disqualification. This is correct. They are considered as unattached members of the House. They are not free as such. If they join any party, they shall be subject to disqualification. So for anti-defection law, they continue to remain a member of the same party with which they had contested. But practically, they are given a separate seat as they are now considered unattached. But for anti-defection law, they are still member of that party. Okay, so these two are the correct statements, 1 and 3. Then this is regarding the procedure to change the name, basically reorganization, where it says what according to you is the most appropriate reason behind the simple procedure in the Constitution for altering area boundary name of any state. Now maximum confusion here people had, and I highlighted also for us, is the second option where it says India is an indestructible union of destructible states. 56% have chosen this as an option, and that's why I had kept it too, to see how many of are able to develop this thinking. And it's a typical problem most aspirants face in their thinking process. Now see, this is a correct statement. India is indestructible union of destructible states, right? It is a correct statement, but it does not mean it is the answer to the question. Question is not a true or false. It is about being reason for something. So in the mind of the aspirant, since the statement is correct, there is a tick. So many of us end up marking it correct without going to the second level of examination, that is it the correct answer to the question. Only solution to this problem is practice. Now, see here. Is this the reason, or rather the outcome of what is asked here? We are an indestructible union of the destructible states. Correct. Because it is easy for union to do it by a simple method, not the other way around, right? Reason is a simple method, and hence we have destructible states. Question is, why do we have simple method? Correct answer here should be actually D. C is also wrong. Historically, the provinces and states were created. That's incorrect. First also has no meaning. Just because states have proposed something, it should be done. There's nothing like that. See, since independence, the states have been organized and reorganized many times to assist in the administrative efficiency, of course, driven politically, right? So, this is the correct reason which was in the mind of our constitution makers why they chose a simple procedure. Anyway, next question is, which of the following statements are not correct regarding the election of vice president? First says the candidate shall be a registered elector in any parliamentary constituency, and for a candidate whose nomination has been made and is found to be in order on scrutiny, they die after the time fixed for nomination and before the start of the poll, the returning officer shall countermand the poll. Hardly 20% got it right, and both are correct statements. These are the provisions of Presidential and Vice Presidential Elections Act 1952. Okay, so since last year vice president election happened and it was in the news, we should be careful that maybe some question may come. Otherwise, also we should be always prepared. So the next question is about legislative process in the Parliament of India. Some statements are made. Let us see. Leave of the House is required to introduce a bill in the House. Absolutely correct. We have seen this in the previous video, if you remember, also regarding the constitutional amendment bills. So that's where we saw that motion to introduce is a separate thing. Then once the bill is introduced, it is published in the Gazette of India. As a general rule, this is correct. However, in some cases, it may even be published prior to the introduction. Then it will not be published after introduction. And in that case, leave of the House will also not be needed. Third statement says a bill is published twice before it becomes an act. Now that's wrong. It's not twice. Bill is published once before it becomes an act and once after, at the time of enforcement. So before it becomes an act, it is published only once. Overall, yes, overall twice it is published. Then there can be no deadlock between the two houses in the passage of constitutional amendment bills. Now this is also wrong. Since both houses have equal legislative power, deadlock is possible. However, the only thing is the deadlock cannot be resolved. So there's a difference between having a deadlock and resolving the deadlock. So we can have a deadlock. Both houses have equal power, but you cannot have a joint sitting. There is no provision for joint sitting here. Both houses have to pass the constitutional amendment bill sitting separately. Then in the next question, it says correct regarding judicial review of a legislation. Now, first statement, there is a presumption in favor of constitutionality of the law. This is correct. The judicial review begins with this presumption, and if any violation is found, it is considered only a mistake. That is why there is no punishment for legislature or legislators. Then the courts do not judge the wisdom of the law. This is also correct. Courts are not there to see the need of the law, whether the law was needed or not. That is precisely the work of the legislature. The work of the court is to check constitutionality. Okay, that is their work. Other things they are not interested. Is it required? Is it not required? That will be the legislative process. Then the last question gives four options and basically features of our constitution which have been borrowed from other countries. Again, not a very exciting performance. Election procedure of the president. Actually, this is from Ireland. This I think was easier one. Centre appoints the governors. That is also correct from Canada. See, in general, anywhere there is a centralizing tendency of a federation, it is largely coming from Canada. Okay. So the third choice, concurrent list. Now, this is also correct. Actually, all four are correct. But technically speaking, for concurrent list, know this, that there is no separate concurrent list in the Australian constitution. There is, in fact, only one list called the Union list in Australian constitution. Same as USA. USA also has one list. Everything else automatically is a state list. However, in Australia, concurrent jurisdiction is all of it listed in section 51 of their constitution. However, also important is the idea that union law shall prevail when there is a conflict with state law. So all these things come from Australian constitution. Then procedure established by the law. This is where aspirants I see often get lost in the idea of the procedure established by the law, which we know is a British concept. It is a British concept. However, it is all unwritten in their system, British constitution. So when constitutions were studied, this idea was taken actually from the Japanese constitution, and it's almost verbatim that we have adopted it from the Article 31 of Japanese constitution into our Article 21. So you can have a look here. It says no person shall be deprived of life or liberty, nor shall any other criminal penalty be imposed except according to procedure established by law. I'm sure you can see how similar it is to Article 21 in our constitution. And here's a small learning for you to close this video. The political spectrum on a linear scale of left to right. Pause and reflect upon it from your own understanding. Thank you for watching the whole video. Continue your learning. Do well. All the best.